Okay.
All right, it's just about 7, so welcome to Conservation Commission meeting. This discussion today will be essentially a discussion of the discussion that we started last month. This is pretty much a deliberative session for the board to go over the materials that we received, to sort of talk about how we think that we should proceed. So there will not be presentations from the various attorneys, and we're not having general open public comment. So mostly you're just going to have to listen to us talk. We appreciate you all being here in case we have questions or there's additional information that we need. I do want again to thank the very many people who have provided input. So we had so many people here in the last meeting, people who have made comments, people who have written to us, people have given us a ton of information, and we really appreciate that. People are passionate about that, and this is great. And we are listening to you. We are reading everything that comes through, and we appreciate your engagement with this process. All righty, let's do a quick round of introductions. I am Allison Watts. I'm the chair of this commission.
Derek Durbin, town council.
Larry Mazur, if I take the minutes.
Christian Alaris, board member. Caleb Fields.
Rob Flynn, vice chair.
Lauren Hill.
I'm Redford, commissioner.
Christine McDade, Commissioner.
Mark Casker, select board member.
Thank you. So basically, we have 2 questions that we have been asked that were given to us by the Attorney General's office, and we really want to focus again on those questions and try not to get distracted by some of the many other issues that are floating around here. I suggest to the commission that we start with discussion of the first question, and we move to the motion and a vote on the first question, and then we do discussion of the second question and move to a motion and a vote on that. Try not to spend too much time bouncing back and forth between them. Okay. Yes, I will try. And if I have a tendency to get softer and softer, just keep interrupting me and telling me. It's not clear to me where the mics are either, so hopefully online they can hear me. Okay, so the first question that we are being asked is this question: parking on the easement under the terms of the easement deed is allowable. So that's sort of the primary, is it allowed? There are a couple of ways we can do this. I really didn't want to sit in the middle because I wind up doing this. But, you know, I'm trying to send equal time. We could go around. I think all of us have an idea. I myself gone through the materials. I'd sort of come up with, I have a concept or an idea of how I think I would answer that question. I would say that my concept is not set in stone. It's evolved pretty significantly over the last month or two of these conversations. So when I say this is where I think I am now, it doesn't mean I'm necessarily going to be there in an hour. So this discussion is an important part of making sure that we all hear each other's opinions and potentially are swayed by those opinions.
Question.
Yes.
So I know between the last meeting and this meeting, there was quite a bit of new information provided.
Yeah.
There was a lot provided via testimony from the public. How do you propose addressing if we have concerns or insights with regards to anything new that was provided? I mean, it's all pertinent to the 2 questions.
Yeah.
But if we have reflections or learn something new from those insights.
So I would say if we want to just discuss what we may have in the last month, a bit about the new material that's come in, anything that people think is particularly striking in the new material, anything that is pertinent that we didn't know before, we could do that at this point.
So I would like to discuss the how agritourism is applied to the easement and the excluded area. So done a lot of reading on that. So there are 2 sides to the deed. So the deed finds agriculture. It lists agriculture, and the deed was drafted before agritourism existed. One side of that is that the deed is a contract. So it's a snapshot in time of what was agreed to at that point. Therefore, agritourism is not included in the interpretation of the deed, right? I've also read from, was it the Supreme Court, that the Butters argument was unswayed by that argument, so that it does evolve. So I just, can we all agree on that portion of it? Like, is agritourism allowed per the deed?
I don't know that we would entirely agree, but we can discuss it. My sense from the legal piece, and Derek can weigh in here, is that it isn't entirely clear from a legal point of view. Would that be? Sorry, hearing anything you're saying. Okay. Try not to yell at them, but yell at you. I'm saying from a legal point of view, my understanding is that it is not entirely clear whether or not the definition of agriculture in the deed should refer to agriculture at the time it was written, or whether it should return, or whether it would include the more current definition with agritourism. And I'm asking.
Yeah, I mean, I think it's a little muddier than that, but yeah, accurate, but I think it is a little more complex than that.
But fundamentally, we all need to make some kind of decision or thought process.
Yeah.
On our own.
And the portion that I was trying to reference as I was talking is, says the court is unpersuaded by the neighbor's argument that because agritourism is not adopted by statute till the conveyance of the conservation easement, that such uses are incongruous with the easement's agricultural purpose. So that was from the Supreme Court of New Hampshire. It's two conflicting things in my mind.
Yeah. Anyone else have thoughts or opinions on that?
I didn't think we were discussing agricultural tourism, we were discussing parking. That's two
Yeah,
completely separate,
it's important because if the parking is related to agriculture,
but one happens on 2-acre parcel, one happens on the easement. We're only discussing the easement and parking.
right, but if parking on the easement is ancillary, is in support of agriculture, whether it's on the easement or not. Is that agriculture, agritourism?
Well, then we can relate to the deed, which goes straight to, it's got to be on-site, land-based agriculture, non-commercial, non-motorized.
So I think it's saying on site on the farm. I don't think you can say that, yeah, it's in the exclusion area, it's not on the farm.
Right, that's what I'm saying, it's two completely different things.
Yeah, one of the things that came to mind me gets down to this, the statute, the 2134A that defines agriculture. And it draws on kind of a memory common sense that I had, that I'm very familiar in the early 1990s, taking my kids to farm environments where there was carolers, free drinks, maybe jugglers, there's things going on like that were right up the alley with what Vernon Farms does well before that. So if you go to the 1999 statute, it does say, it lists out agriculture mostly as a production of goods and raising livestock, whatnot, but there's one number 5, and in 1999 it said the marketing or selling at wholesale retail, on-site or off-site, where permitted by local regulations, any products of the farm. It says the marketing or selling, okay? The 2004 version of it, which postdates the deed. Point number 5, marketing or selling at wholesale retail, regardless of the manner or form of the transaction, any livestock. The same sentence goes on there and then elaborates a little further, says including agritourism, where it could be, I'll say, a concert and entertainment, things like this. So I think from my memory of the events actually taking place at farms prior to 2014 and earlier, and my own experience and the statute, it mentions marketing. Now, I think some of the activities there are farm produced, mostly goods, potentially some services, but commercial things are goods and services, and marketing is very much tied in with a business. The last business I was in, they had a whole division that was the commercial side of the business, and that was the sales and marketing people. They were embedded in there. So if it was always determined to be marketing, well, if it was in 1999, then it does predate the deed in my mind. And it probably was an earlier version of that too, but I had the 1999 version. So that's my thought on that. So I actually think it's covered.
So,
And by the way, there might be, the Attorney General might, completely, knock me down in some kind of sterile decision, but that's kind of my personal feeling and experience with the type of things that is being done at the farm.
so I don't disagree. I think that there is the ability, obviously, to enjoy the farm, and that's part of what has been explained in numerous documents. I think the crux of it is we're getting back to is parking on the easement. And so what I would say is that I've not found many, if any, examples of parking on conservation easement. I don't think it's good conservation practice. But additionally, what we've seen in the deed, and again, I'm a firm believer in the sanctity of the deed as conveyed. There's not anything in the rights or in the anything that alludes to parking. However, what we can see in the deed is that area has been left outside of the easement, which to me was done purposely for parking. So I don't think anybody's disputing that there shouldn't be activities at the farm. Parking on the easement is what's at issue. And there is property that is left outside of the easement. I would also, I do, and I think the quote unquote missing Sarah Callahan letter, I think is an important letter because it does raise a distinction where she notes in that her exact words are the primary product sold and advertised is not in fact chicken dinners, but live music venue. So to your point, Tom, I've been to lots of farms. The music is free. I'm there to enjoy something else, to purchase farm goods. So the agritourism, the two at odds that I struggle with are not what you're suggesting, but what the primary reason is doesn't seem farming based, number one. And then also the parking on the easement. Other farms I've been to, the parking is not on the easement. I don't think it's good conservation practice. So it doesn't seem logical that you would do that.
It is on some of the farms, right? Because we have a couple house and some of those others.
Couple House is interesting because somebody put that in our files and I did take a look at it, but they do have specific language around parking. And there is in Couple House, whereas this is not entertained in the Anderson easement, in the Couple House easement, what I did find, because I looked for something, under the reserved rights, the grantor reserves the right to use, maintain, repair, relocate, and replace the existing driveway to serve as a reserved lot on the easement. So there is specific language. So while Couple House may move it around or allow for parking, there is specific language in their easement, which doesn't exist in the Anderson easement.
But I think you can take it both ways because the fact that it does not exist in the Anderson easement, it's not excluded, right?
it's not permitted specifically, but it's not excluded either.
You don't have to exclude. It would have to be included. It's not the purpose to, if we started interpreting everything that was excluded, we could have a lot of fun. But
So I want to jump in.
Yeah.
Those were my notes from, I actually talked to several other conservation commissions.
Yes.
And those were the ones that I thought were most relevant.
okay,
Mostly they just express sympathy for all of us.
Yeah.
But in Lee, and specifically, they do allow parking on easements where parking is not mentioned. Not any place where parking is forbidden, but there are places where parking is not mentioned.
Hmm.
And they do allow it under very specific circumstances. But they're not saying parking is okay under any circumstances. They're saying it's
Correct.
very closely tied.
right.
I would also say that they and most of the other conservation commissions that I spoke to were pretty clear that they were using the definition of agriculture that was in place when the deed was written. So they were using that older definition of agriculture.
And that's my understanding too of the purpose of the easement deed, right? I know there were conversations about changing with the time, but I think the intent of the easement is to actually secure it for conservation, for perpetuity, for everything that's expressed within the easement.
And I think for me, that's a place where I think my thinking has changed because when you look at the Callahan letter, she does say agritourism events specifically. And I think at that time, we all thought agriculture equals agritourism, and I'm not as convinced of that anymore.
I agree.
So one other,
But also the farming that's, you know, she wanted to have it available for agriculture. But the agriculture of today is different than the agriculture from 30 years ago. And what I understood that the family did at the time was mow hay and produce some vegetables. And that's not going to sustain a farm of the size that it is today. So you know, we've talked some about, we've heard some people saying you have a fiduciary duty to protect the value of the property. And part of the value of that property is that it's a farming property. And so to allow a farmer to produce farm products and market their farm products in a current environment seems to make sense to me.
I would suggest that you're conflating issues. I think that there's an easement for a purpose. And if we're to change the easement, which I don't think the sole responsibility of a conservation commission is to uphold the easement. It's not for us to modify or change. I would suggest,
And I'm just talking interpretation.
but I would say though that I don't see a portion in the easement where it talks about changing any of the language of the easement or the interpretation of the easement.
so I don't think we're talking about changing the language of these. That's a
Okay.
huge complicated one. So the place where I think that parking is potentially allowed under the easement is under section C, ancillary structures and improvements including but not limited to. And then there's a list of things that are allowed. Parking, I would consider an ancillary structure if provided that it is ancillary to the agriculture uses of the farm. So I think, to me, the easement language is not specifically disallow parking. It doesn't specifically allow it, but it has this kind of open category. I'm sorry, I'm trying to talk louder.
Yes,
It does-
because I can't hear you.
Okay, it does have this
For their benefit, you gotta.
open category of,
You do have a microphone here if you want me.
would that be helpful?
Great.
That's where parking comes in.
Yeah.
So we still need to buy them. And it will be recorded.
All right,
They'll be recorded properly.
let's move, I'm giving this back to me.
You can keep.
And I'm gonna swap places with you. Can I swap places with you? Yeah. That probably got.
On my note,
I think you're probably the same pile of paper.
What section were you referring to?
Section
C,
C,
page 6. Page 6, section C.
And while we're talking about that, so I think also I'm gonna weigh in on this question that it is related. Sounds like I'm going off on a tangent, but we have been talking a lot about Mrs. Anderson's intent and whether or not what her intent was when this deed was written. I am not particularly comfortable with having other people interpret what her intent may or may not have been. She isn't here to speak to her intent, but she did sign this deed. And to me, when she signed it, she was probably envisioning agriculture as it was defined and understood at that time. So regardless of whether legally we are obliged to stick to that older definition, to me, it feels like that is honoring Mrs. Anderson's intent. So I am inclined to continue with that, using that older definition, partly because of that. So that's another piece that's pushing me towards that older definition. I'm having trouble figuring out who I'm talking to, you guys or you guys, but so that's sort of where I've come to in the intent piece and the definition piece. I do think that parking is potentially an ancillary structure. The fact that it's potentially allowed doesn't mean that it's allowed under all circumstances. So that is not, that's another set of this conversation. But the first piece of the conversation is it potentially allowed under this deed? And using, no, it's not even, we do need the older definition of agriculture because it's allowed in section C. Place here.
Oh, you have it.
I do have it.
Yeah, it's right here. See?
It's right here. Right. But in general, all of these things are only allowed provided they meet the purposes of the easement and they are not detrimental to the purposes of the easement.
And on site.
So I think, I mean, again, on-site land-based agriculture.
Gotta be on that site, not the exclusion site. So parking is allowed on there. For something happening on that site, not off site.
I guess I don't see why the part of the farm that just doesn't happen to be on the easement is not part of the site.
Part of the site, it's just not part of the easement.
Yeah, I think it's just not under the easement deed, but it's part of the farm.
Then why are events held on it?
It's what they've chosen to do.
No, the events aren't allowed on that.
I think, and I
They're
think,
allowed off site.
yeah, and we're getting into what the planning board site conditions were. And my understanding that that was the proposed plan, and I don't know what the logic behind that proposed plan was. And I don't know that that's our discussion.
The farm environment is partially in the exclusion zone, but is almost all in the easement, which the public gets to see and the animals and you and all that. That's the benefit for the people going there.
And the easement also does allow forestry and so forth, which would require much heavier equipment, more soil disturbance, I think, than parking for occasional events.
We're not talking about forestry.
That's part of the agricultural, that's part of the terminology of agriculture in the easement.
Well, in that same paragraph that Allison brings up, it brings up non-commercial, non-motorized.
I think that's an important piece in that, in particular, when you look at, so I went back and revisited, and I'm sure we all did, Francis Lane, the attorney that drafted the easement. And when he was here and he spoke, he talked about the use limitations in paragraph 2C that strictly prohibit any industrial or commercial activity except certain agricultural and forestry activities as defined in the easement at the time it was executed. And then he emphasized when he spoke later changes in the state law, for example, goes into agritourism, do not modify the original contract. The town must adhere to the terms exactly as listed when Meg signed the easement. So there's nothing in the use limitations that I would say that parking doesn't adhere to forestry or agricultural activities. Right.
I actually got lost there.
So he suggested that it has to be any activities, motorized activities would be directly related to agriculture or forestry. So driving on the easement would specifically have to do with agriculture. But what we're talking about here is we're talking about parking on, I mean, it's pretty simple if you distill it down to parking on the easement for non-easement activities.
I don't think so. Because I think if it's a non-easement activity that is agriculture from that farm, then I think it's on site.
If you have already have land that's outside of the easement,
But it's the same farm.
right? But you have land that's outside of the easement that can be parked on.
So I think that's actually an important point, and I'm very interested in that point. I don't think, I think there's this basic question of, is it allowed if the circumstances are right? So it's not.
But that's a modification of the easement.
Arbitrary.
Sorry,
We're talking about
circumstances are right,
modifying.
it's bad language, yeah.
Yeah.
So if it supports agriculture, is that?
If it's an agriculture or forestry activity, yes. So if it's we're foresting land, we're tilling land, forestry activities, agricultural activities, yes.
Okay, or this other piece of.
Parking, I have a hard time, if I'm looking at easements, saying that that is a agriculture, I think it's a real stretch to suggest that that is a forestry. If we've all come to the conclusion that agritourism didn't apply at the time. And I think the other part is we're trying to see something that maybe isn't necessarily there. I think the reminder for all of us is here that we're here to uphold the easement and not look for activities that are not listed in the easement. That's
Marketing can be a lot of things. Marketing is not just selling the product, it's promoting the product.
sure.
And so you can do a lot of things like bring people on site to do other things to promote the product.
For example.
Like a musician,
Sure.
because you're attracting people.
And
Encourage.
I think that's what we're talking about as far as like an apple press farm or the examples that Tom was providing, that music on a farm. And yeah. But I guess that goes back to the initial question that you posed, is parking on the easement. Is being allowed on the easement. And I've not seen a good example other than Couple House, which was given as an example, but has specific language with regards to parking.
First, I think I read actually a few places in the Superior Court decision about you can't put words into legal documents. You can't put a new, it just says you're getting to.
Yeah.
So maybe an easier way of looking at this, is there anything specific in the deed that prohibits parking? Yeah.
Stop.
Yeah, the section C(I), no such improvements only is necessary for the accomplishments of on-site land-based agricultural, forestry, conservation, or non-commercial, non-motorized, low-impact outdoor recreation uses.
Caleb, the word parking's not in there, and I non-motorized, low-impact recreational uses to me is dirt bikes and four-wheelers.
Well, you're
Like, I think that's pretty clear.
You're just arbitrarily adding words.
No, but I mean, that's,
So agriculture is, I mean, this is also what Tom brought up. And this is, under this 1999 definition of agriculture, production, growing, harvesting, sale, and this wholesale and selling offsite. So is that not agriculture?
Could you just repeat that?
So this is, as Tom pointed out, in the 1999 definition of agriculture. So if parking is allowed in support of agriculture, that,
So can you read from the
Yeah.
definition?
so the definition, this is the older definition, the marketing or selling at wholesale or retail, on-site and off-site, where permitted by local regulation, any products from the farm. So for instance, food.
Farmers
growing on-
market,
Yeah.
yeah, sure. Exeter Farmers Market.
So going outside the easement area and buying and eating the food that was grown on the farm.
But that doesn't specifically say parking. And I would ask, what would parking have to do with on the easement as a,
It doesn't specifically say parking. It also does not specifically say no parking.
I know, but we could, that's really, we can play the game of what it doesn't say.
But then we can
and again-
boil it down, then we've got an unanswered question, boil it down to paragraph 1. Says who can answer that question. Executors, administrators, legal representatives, heirs, successors. We have a letter from the trustee and successors explaining the intentions. They are the voice right now.
They don't specifically say anything about parking.
Exactly. They don't.
We have
It's
a letter from
been
them.
specifically left out. I think it's an important point, and you raised this at the onset, which was there were a lot of, at the last meeting, and that was something that I thought a lot about. Everyone got up, and Meg Anderson was a popular person last meeting, and talked about what she would have wished. And I never met Meg. I don't know Meg. What we're left with is the document that she provided, which is everything included in the conservation easement that several legal entities have said what's conveyed in the easement at the time of conveyance, and that is the sort of the document that has been sanctified. So when we look at that, and several Francis Lane and others mentioned that it's preserved exactly as written, not to be revised or changed with the times, etc. To Caleb's point, I think the closest that we have with regards to who knew Meg's intention, and we did have several that had firsthand knowledge at the last meeting that I think we should refer back to. And those folks were, as Caleb mentioned, the estate representatives, which were the two individuals who had direct knowledge and legal authority to carry out Meg's wishes. And that was Robin Neely, who's the executor of her will, and Dorothy Ayotte, who's the trust. And they had sent an October letter, and I know we all got the letter. I think parts of it were read at the last meeting. And they talked about how this is, I think one of the most powerful pieces in that was that they said we can unequivocally and confidently state that this, in particular, the parking, was not our aunt's intent when putting the land that she took much pride in into conservation. Direct quote from the letter. Not a secondhand interpretation. To Caleb's point, probably the only two that knew her wishes and have some legal authority. It's a direct connection. The other was Francis Lane, which I just mentioned, we talked about prior, who emphasized what I mentioned, the later changes to the state law don't modify the original contract, that we must adhere to it as Meg signed it. And there's nothing in the use limitations that hints at parking, particularly on non-agricultural or commercial, non-agricultural or commercial purposes. The last person I would say, and this was something that just came to light, that was, we had in our possession, but that McLean had pulled from our records, which was a 2004 monitoring report. And at the time, Chris Kane was the conservation assessor, and it highlights in his language how he sat down with Meg and that she expressed directly to him under use limitations, and it was what you cited, previously, non-commercial, non-motorized, low-impact outdoor recreational uses within the easement. So with that piece really underscores the fact that we're talking about motorized
So
and
mean,
recreational.
I feel like we've been talking a lot, so I'm gonna put this down. Does anybody else down there want to weigh in here? I mean, I don't think that going and parking on a spot so that you can go and do something else is motorized.
So,
You have to get there.
so that it does beg the question that others have brought up similar easements with similar language. So it does open the door, in my view, to others suggesting parking on their easements for the enjoyment of the property. And then in which case, I guess it begs the question, then why put into a conservation easement? And I think the Donovan letter and several others pose the same thing. And I know that we received several letters from the public about why should we put our land in easement if it's not going to be honored and protected by the Conservation Commission. So I think it does open up the Conservation Commission to plenty of challenges in the future.
I mean, other commissions, as we've mentioned, other commissions are allowing parking on the easement.
Examples. I think we need examples.
Okay, so there were two examples I don't remember if I wrote them in the notes that I came from Lee. Burley Farms and South. I just parked cars there the other weekend.
And is there language in the easement like couple house? There's no language. So
Was that a failure on their conservation committee?
I am not going to hold the Lee Conservation Commission to whatever.
We're getting called out for failure from the Anderson representatives.
I've said, I
Speak up even here, I'm having trouble.
appreciate the input from those relatives on both sides of the fence, but I do not think that they can effectively communicate the wishes of someone who is not here and who's
but that's the
unlikely
purpose
to
of the
have.
easement. Is
Yeah,
that
It's a legal
it's
document,
communicated with
It
the
does.
putting their voice up front.
And the legal document says that she wanted farming, she wanted viable, economically viable farming.
So I have a question for you, and this is maybe for Derek, but so in it, as far as ancillary structures, Meg or Francis, in the easement, it lists what they consider ancillary structures. So if we're considering driveways or parking lots, ancillary structures, now we're talking about a structure. Is that a stretch, or can we as a commission impose our intent on that? And if not, does that require, my understanding is the executor of the deed, it would have to go through some approval. So I guess it's a two-part question. One, are we able to interpret outside of the list of ancillary structures, other structures ourselves as a commission, which I don't believe we are, because again, my understanding of our authority is that we support the easement as drafted, not to, and what I read is not to modify, not to reinterpret, et cetera. So the first question, can we impose our interpretation on that? And secondarily, does it need to go through some sort of legal approval through the executor of the deed?
So I think the first part of the question is, well, I'll answer it. Going to page 6, subsection C, right? It says no structures or improvements, including but not limited to a dwelling, office, any portion of a septic system, tennis court. Is that the section?
Yeah, I think so.
Okay.
Yeah, and then the last
And
sentence in
then,
there.
however, ancillary structures and improvements, including but not limited to. And I think that's probably answers your question, is that yes, there is, it gives examples, but it's not anything. And all
So is it an improvement, I guess, is the question. And that's where I think there's some great language, and I know that this has to do with the state's requirements for an amendment. But again, I'm also kind of a purist there. If I don't believe in reinterpreting it or reading into the easement in any way, but there is some good standing when it comes to guidelines for amending or changing easements. And while it seems like an incredibly rigorous process, there are 7 things that must be upheld. And I think that they're good guiding principles for making these kind of decisions. And just to cite them for knowledge,
Can you summarize really quickly?
I'm going to read all 7 very quickly. I know, but I think it's important. Number 1, public interest. Is it for the public interest?
It's a side pay type of.
Right, you're
Yeah.
talking about change.
I just, I'm.
I am,
language
but what I'm saying is these principles apply if you're looking through it lens of, I mean, again, as a commission, I don't think, and somebody can point to where I'm wrong, but I don't think we have the ability to reinterpret or add on to this easement
We have to interpret it.
as written. Correct.
Yeah, just from a legal standpoint, Chris, yeah, you can't add on, modify the terms of the
Okay.
easement. I think where you guys are getting hung up on this is, it doesn't say, yes, parking is allowed. No, it doesn't say parking is
Correct.
prohibited. Ultimately, I think the umbrella question I'm trying to answer is the parking part of the agricultural use of the property?
In this case, isn't.
Look at it as a very, is a bigger picture question rather than trying to break it down into component parts of the easement, whether or not it's structure and improvement. I don't, it's not listed in any of those examples, right? And I
Right.
think everybody can agree on that, but I think the larger question is it part of that agricultural use of the property? I mean, that really is the question.
And we have a direct correlation directly across the street on the Burn property. And that was denied parking. And that's not looked over by this committee. It's actually looked over by SELT, which is an authority in this area. And we can use that as an example.
That is a
You
very
guys
big
can-
situation.
But
This got some
denied that.
direct the questions at me, though. I'm just trying to.
How's it different though? Sure.
Framework from which.
I believe that easement, I think, specifically refers to parking, and my understanding, I mean, I wasn't there, so I wasn't
Never-
part of it.
The verbiage is almost identical. The same person wrote both of them.
My
They're almost
understanding was that the
identical
request for parking was not specifically tied to agriculture, but I wasn't there, so I can't interpret that. But I can say this is what we're working on. We are commissions here. We're not SELT.
Right, I'm just saying, SELT is a great example as an authority in the area. on it,
They
and it
had
was
their
denied.
reasons, and it was a very different circumstance. So for better, for worse, I mean, we don't have to come to consensus on this. We're going to discuss it. I want to make sure that everybody feels that their opinions have been heard. We have not heard from Lori. If you want to have anything to say here?
I think that if there was agricultural activities going on as defined in 2004, the easement, it should be allowed. And in this case, it's chicken. So I'm not sure. I mean, I think that it's very, I think we needed from the very beginning to have more input on this. And we were never asked by the planning board. And this should have happened a long time ago, before all that happened. And so that's the thing is, I would say parking's okay as long as it is defined by the chicken, which is what, or the pigs or whatever. Visiting the farm.
So now I'm not hearing you.
I think it needs to be limited to the agricultural activities. And also whether we have the power to limit how much of it happens. I mean, all that was defined by the planning board before we had any input. I,
But to that, we've now had 3 planning board members come up say that their decision would have been different had they been,
But they didn't ask the conservation.
May I?
right, but there was a memo that was never given to them.
So let's, I would rather not go into that back history. And I know
I
there's
think
a lot
it's
of
important.
frustration.
And I'll explain why. Because we have new board members and I don't know that the public is aware. And so I personally, and I emailed you about this, that there were concerns. There were several things brought up and honestly, if people are not aware, and I'm not sure other board members are, but I wasn't aware of we received a letter recently from John Hayden that laid things out. And I think, I hope that everyone read it, but I wasn't aware of how things transpired, nor was I aware of how we sort of got to where we are. And I think that's an important piece. And I think this is an important meeting. There are lots of people with different stakes. And I think to ignore the past and what has transpired, and to Lori's point about not knowing, I think the dots are there. And so I would like to take a moment and I know that there are probably only 2 board members that are on the board at the time of that vote. So you may or may not recall, but as Caleb pointed out, that there was I think several, Hobie, Harmon, Mike Sununu, at the last meeting, both brought up that the planning board was in accordance with their testimony up at the stand last time, that they were never provided the Sarah Callahan, and that was what I was calling the missing memo, because I wasn't sure about that, but that impacted the December 8th decision with the site plan modifications holds, because I think it's important. And I think it's further owed a little bit of examination in light of John Hayden's letter that we just received, but also Attorney Manzelli provided us with that decision to re-examine in our latest files. So I think to not examine it when so many people highlighted it, I think it's important. And in John's November 3rd letter that he provided us, he said that former Conservation Commission Chair Jeff Kuchar, who he noted in his letter was serving simultaneously as the Planning Board Chair and as the Conservation Commission Chair at the time of the decision, told him, and this was John Hayden's words, not mine, that the Conservation Commission had discussed parking within the easement and regarded parking for events as permissible use. So there was a statement provided to by the Conservation Commission to the Planning Board.
So I would
And
say
then-
if the newer members of the commission feel it's important, we can go through this. I don't
It's
think
not
that it's
long.
relevant.
I
to
think
this
it is
particular-
highly relevant, and I think it's worth pointing out.
The rest of you feel that this is important.
I do want to respond.
So do the rest of you feel that it's important to understand this history for your information now? And
I
we
think
can
it's
go away.
important
I'm
because
fine
she
with
just
that.
said that and her decision was based off the planning board approved that. But we've now heard from 3 different members.
No, it's not based on it. It's that
But I would,
the planning board did not come to us as a commission to ask our input about parking before they approved the site plan.
because according to John Hayden, and I have to ask,
Future is not the Conservation Commission.
but he was at the time of decision.
He was a member.
He was the chair of the commission at the time of decision.
Chair. Right.
Okay, but fair, but
That,
The point
you know,
is-
this is word of mouth. I mean,
Yes, and that is word of.
well, I have John Hayden's word to put to it, but the bigger point is that from what he points out,
Right? Laurie was there at that time.
right?
So her
So,
opinion is.
so then, I guess the question that I would ask too, based on that, is that, so John notes that affected the vote, et cetera, et cetera. But I would say that, that he mentioned that, so they took that as the word that, that this had been discussed. But then on top of that, to your point, Lori, if John is saying that he was provided that decision by Jeff Kuchar at the time, and three board members, two of the board members and one selectman last time had said that they had never received the Sarah Callahan memo, which again, that would be.
Didn't know they were discussing it at the time. We had no idea.
So did you receive the Sarah Callahan memo? There's nothing in, so here's the piece.
The thing is, we didn't know the planning board was doing this site plan.
So with Jeff.
Why would we give it to them?
So here's the question, and that's an incredible lack of communication, I guess. If I've got Jeff Kuchar sitting on both boards and you had no idea, that's
Because
mind boggling.
you talked about Conservation Commission. Ask him.
This is a failure,
So
both boards.
Just let me, I'm gonna,
History.
and that is history. Okay.
It absolutely is history, but it has impacted as to where we are today.
history, we don't have videos and that kind of thing, but we can go just by the documents we have. And I'm newer too, so I certainly wasn't around. But the planning board was on December 8th that year. The memo came out on the,
Noted.
okay,
On the what?
the 12th of December.
5th, the December 5th memo.
Okay, but if
Yeah,
they didn't get it in time, they said for
they
the,
got it after.
they got out. But the very next meeting in January, which has good minutes of the, this is planning board minutes here.
Right, because they were told,
And they're talking about the Vernon Farms and there's not a peep about parking.
I would have to,
Because
they were
Okay.
provided with a response by Jeff Kuchar saying that the board had discussed it. Now, to that point, I would say that I looked through all of our minutes. And if it was communicated to the planning board that it was deliberated and decided upon, I did not find that in our minutes anywhere, to your point, Lauren.
I wasn't the planning board.
We'd have to ask.
Reading the right act at that point about not getting this memo. There's not.
Because they weren't aware of it.
Yeah. You guys, I understand that this, we could spend the entire night talking about this. Okay, and this is, I understand that there's a lot of confusion. I understand that probably there was a lot of miscommunication, but we are where we are right now. And we are
Exactly.
asking.
It's
the
important to
straight-
understand the history.
Okay, and I get that you guys, and frankly, I wasn't there for all of this either. But this is where we are. Those conditions are in place. They could potentially be revisited, but under those conditions, one of them says, as I'm recalling off the top of my head, that parking on the easement or anything having to do with the easement needs to be approved by the Conservation Commission. We are being asked now to do exactly what Lori said should have happened. We're having this conversation now. So maybe
And my point
years later,
is,
short, but we're having the
my
conversation.
point is, my approval really is contingent on numbers and amount.
Numbers and amount.
Leave that.
Numbers of events.
Yeah.
Amounts of people. I think that makes a difference.
But I think we're still on the first question. Let's just start with the first part of the first question, which is parking under some circumstances? You know, it's easier if you flip it around. Is parking prohibited by the easement language? And the question we're being asked is, if it's not prohibited, is it permissible under the terms of the easement deed? And she says, because members of the public, I think that we could say, is it permissible because it supports agriculture? And regardless of what the planning board says they can or cannot do, I think that's the question that's in front of us.
Can I say something?
No,
I'm gonna say something.
no,
Wait,
no, this is not a public comment period.
Fall.
Ma'am,
You're trying to fall and you're out of line because Meg Anderson's not here to speak for herself, but her executives were.
The letter.
If you allow this,
Excuse me. There's no more, please. There's no more of that. This is a deliberate,
standing up for somebody that had a decent.
I understand that
For their wishes.
there's a front, there's a problem.
Can't do that. You cannot. This is a public meeting.
They can't do what they're
They
doing.
can. They have every right to hold a meeting without input from the public. Stop it.
I mean, call the police who are assumably around somewhere if we need to. So I am trying to focus on this question, which is the first question. I understand that if we were to agree that parking is not forbidden, that there are circumstances under which it is allowed, that doesn't mean that we're just saying parking is okay. It doesn't mean that we're saying parking can be as much as they like. We're just saying, is it allowed under specific circumstances? That's the question that we're asking. Okay. Are we ready to make a motion on that question? Is there addition?
I think we are, but may I suggest, because the second, I mean, the second point of the Attorney General, it may be moot if, depending on what we find with the first question, but I think that given the gravity of the decision and every person that it impacts, I think that a simple yay or nay is not sufficient. I think we owe it to the Vernons, we owe it to the abutters. This has been dragged out for a long time, and I think that even each of us should state for the record why we're voting the way we are to justify our vote. Leave nothing on the table.
I would leave that up to the commission members if they feel comfortable saying that.
Fair.
Okay. I can make a motion. I will say, we spent some time thinking through possible paths. So there are some motions that we have thought about that went in both directions. I can do that. Does somebody else want to make this motion? The motion?
Good of you.
Okay, the motion that I would make is that parking, the commission finds, and this, I think we're going to wind up modifying this language, but the commission finds that parking.
Like what, the easement fee?
Excuse me, ma'am. Please be quiet. The commission finds that parking in the easement area by members of the public is allowed because parking is a permitted use by the express terms of the easement because it supports the practice of agriculture, including but not limited to the marketing or selling of farm products and outdoor recreational uses of the property, regardless of whether agritourism itself was a recognized form of agriculture at the time of the easement deed was conveyed to the town of Newfields by Marguerite Anderson. I'm gonna put.
Would you just say it one more time, please? It's a lot in your soft.
Okay, I will say it one more time. I'll even stand up because it's all that teaching. I will say that. Now I'm just going to go ahead and modify it slightly on the fly. The commission finds that parking in the easement area by members of the public is allowed because parking is a permitted use by the express terms of the easement because it supports the practice of agriculture, including but not limited to the marketing or selling of farm products, which is a reference to the 1999 RSA, and outdoor recreational uses of the property, which is specifically listed in the easement deed. Sorry, I'm putting words in, but those are not the words in the, regardless of whether agritourism itself was a recognized form of agriculture at the time of the easement deed was conveyed to the town of Newfields by Marguerite Anderson, provided that it is shown not to be detrimental to the purposes of the easement. You all will notice that I added that last sentence in because I think it belongs there. Do I need a second on that motion?
Second the motion.
Okay, and that motion is up for discussion. If we have anything more to say.
Say again.
I said that motion is up for discussion if there's more we can say.
I'm willing to justify if we're ready to vote our respective votes on that
Okay,
motion.
let's give people, so we all set? Ready to vote? Okay.
Yeah, Scott, how does this play out with a vote in either direction for subsequent motions?
So we will vote on this. Whether or not it passes, the other two motions potential motions that we have are related to the second question. Is that what you're asking?
Could relate to the second question?
Want me to read the second question?
Yeah, we should.
Right now.
So I don't,
On the first question right now.
I don't have a motion for the second question. I don't want to do that at this point. That satisfy your question, Tom?
In this document, it's lowercase I that is
Yeah.
the lowercase I, but you added on.
Yes.
C, lowercase I.
Okay. If there is no other discussion, we will go ahead and vote.
Can we reread it? Can we restate
Can
it
you do it
again?
one more time? Clarification.
Okay. Without my commentary.
So,
The commission finds that parking in the easement area by members of the public is allowed because parking is a permitted use by the express terms of the easement because it supports the practice of agriculture, including but not limited to the marketing or selling of farm products and outdoor recreational uses of the property, regardless of whether agritourism itself was a recognized form of agriculture at the time the easement deed was conveyed to the town of Newfields by Marguerite Anderson, provided it is shown to be not detrimental to the purposes of the easement.
thank you for that. I think it says express term, but doesn't that mean there's direct language to that effect? Because I don't think that's,
I'm just going to check in with Derek.
Say terms.
okay, I mean, that makes it accurate, I think.
I agree. I would like to remove that part.
My red pen.
And then the provided is shown is rather general.
Provided.
So, provided is shown not to be detrimental for purpose of the easement. So
Right.
that's rather general. I don't know if that speaks to even what Lori was interested in.
So I'm sorry.
I think his question is, if we vote yes, then do we have the power to limit?
Yes. Yes, that's the second one.
That's what he's asking.
And in the second one, we can also be a little more clear about when we say detrimental to the purposes of the easement, what do we mean about that? We can cover that later. Okay. All right. I'm going to call a vote on this. All in favor? We will just go around. We won't do the all in favor. We will go around.
I would say nay, and I owe an explanation to that, and so I would like the allowance of just a bit of time. But I would say, for me, knowing that our responsibilities, legal, fiduciary, and otherwise, are to the Anderson easement itself as conveyed, is sort of my guiding principle. The fact that we are, as commission members, held to the oath that we all took to protect the resources, to uphold the conservation easement with impartiality is key. And there really are three things for me there. Under RSA 36A, the charitable trust law, that we must administer an easement according to its written language, its plain language, and its original intent. We can't reinterpret the easement or accommodate later business practices, opinion, or otherwise. Our obligation is to enforce the easement as it stands. The easement restrictions and reservation rights define the outer limits of permissible uses. If it's a use that's not expressly reserved in the easement itself, then it is prohibited. Parking is not listed anywhere in the easement as a reserved right. Therefore, in my view, it is not permitted. I would say that in addition to that, and I know I mentioned this, that Meg intentionally left land outside of the easement, and I suspect that that was for parking purposes. The second point I would want to make is that the easement, as we discussed, prohibits industrial commercial activities. It's mentioned that it must remain an open space, maintained in perpetuity with no industrial commercial activity except agriculture and forestry as defined within the easement. And even that, if you look at section 2.3A, there's a set of items there that talk about what's reasonably accepted. Parking for events, especially those outside of the easement area, is not agricultural forestry activity. And so it does not support non-agricultural, it is a support activity for non-agricultural commercial purposes. And the last one is the agritourism piece that folks have brought up. In my view, with a conservation easement, standard rules of deed and contract interpretation apply. An easement is interpreted according to the meaning and intent at the time it was granted. Later statutes such as agritourism don't apply. So the easement does not reference RSA 2134, which is with regards to agritourism. So that piece is irrelevant. I guess the fourth point would be that the implications that it has on other easements. So with that, I would say I'm a nay.
Okay, thank you. I vote aye, yes. I don't feel my interpretation of the language of the easement deed is that it does not prohibit parking by members of the public because it is potentially an ancillary structure, but it is allowed provided that it supports and does not negatively impact the other purposes of the easement.
I'm gonna say nay, based on in the easement, section C, non-commercial on-site. Further in the easement, the burden of this easement conveyed hereby shall run with the property and shall not be enforceable against all future owners and tenants in perpetuity. It's forever. This isn't changing. We can't add words to it. And the CTU goes on to believe, state they believe the easement requires that activity be for agricultural on the easement property and not somewhere else. They look at it as two different properties.
I vote aye. My reasoning is that the parking supports the practice of agriculture and it is not expressly prohibited in the deed.
Vote aye, and I concur with Josh.
Yay for me for similar reasons to Allison. Section 2C lists 12 items that are prohibited, and parking is not in that list of commas. If it was, it would be very simple for us, I think, but it's not in there. So it's not prohibited. There are other easements that do have comma. The one I saw earlier said, no asphalt. So kind of, that would be implied for a parking lot. So I don't think it's prohibited. And it's rather silent to whether it's in what instance it's allowed. But I would say that from my understanding of this wonderful woman, Meg Anderson, who's contemporary of my mother, who passed about the same time, she would have been very much into practicality and what common sense would be. And to me, the idea that Meg would have the farm and have as much public interest as she had, and would, if a school bus came in with kids that wanted to see the environment, or a work group, or just neighbors and things like that, or a party and whatnot, I don't think Meg would have said, yeah, you got to park right next to the house. where, you know, you could squeeze in because this hayfield is property that you'll ruin by parking there for your one instance. So I don't think that would be in her motive to do so, but there's definitely within that, the limitations on quantity and frequency that also play into the soil quality and some of the scientific aspects of the soil chemistry and physics. So, thank you.
Thank you.
I would vote aye as well, that I believe that this is in support of the agricultural use of the land and that protects the value of the land and the preservation of the land as a farm community, farm environment.
Okay, the motion passes. Thank you all. We're halfway there. So the second part of this, does parking in the easement area, the second question is, does parking in the easement area significantly impair or interfere with the conservation value of the easement? Has the town taken sufficient steps to determine that the parking does not negatively impact the soil? And if parking does negatively impact the soil, can it be remedied afterwards, i.e., are the negative impacts merely temporary, and by what process? So there are two sets of, there are two parts to that question, and you might jacket that. One is, has parking already negatively impacted the soil? And the next question is, has town taken sufficient steps to, has the town taken sufficient steps to determine whether or not it has been impacted? And if so, what do we need to do to remediate? In this section, in this discussion, we are called out specifically to consider soil impaction. But I think this is the part of the discussion where we can talk about not just soil impaction, but other impacts, negative impacts to the easement. Are there thoughts, comments or discussion on this question?
I would say that the lack of data that we have says that we have not gotten sufficient information about the soil quality, and that is something that we can do as a conservation commission to ensure that the easement is protected and the land is protected for the future. So I believe that there is more that we can and should do, and that needs to be agreed on us and with the appropriate experts and the current landowners to ensure that they are following through on commitments that they've made.
Other comments and thoughts? Becky, Caleb, I'm working my way up. Comments and thoughts down there?
I think we could take additional steps to determine. We have no data, no insight.
Can I ask Nicole a question? So who did the soil testing in 2014?
That's a good Jeremiah question. I'm sorry, I can't answer that. I don't know.
Because I would think they would have the data. They did the testing.
The soil testing data doesn't have any relationship with information about soil compaction.
No, I know that.
Yeah. So, and so the 2014 soil testing data wouldn't have any of that information regardless of who did the testing. I'll make an educated guess that it was probably UNH Cooperative Extension.
It probably was.
Yeah. Yeah. So it's just a guess.
I was gonna bounce to the NRCS, which, we can't require we can't specifically ask for the testing, but you can. I don't know if they charge for it or not. I know they're a nonprofit. That was one of the things we'd asked for, was the mitigation records and the soil testing, but we didn't receive anything, correct?
Right. Amy did explain in her letter.
Yeah. You didn't receive nothing. You received an explanation.
We did not receive the soil testing results. We received an explanation of why. Another.
Oh, and we can confirm.
It was.
Yes. In your recollection, when you say probably not compaction, so that would have been more like soil characteristics, nutrients, things like that.
Yeah. Ion exchange, nutrients, organic content, your typical, what do I need to amend my soil with?
From 2014, not
From 2014. I'm starting out at my farm. What's my baseline?
There've been a heavy metals or
I don't know. New farmers often, this is just a generic statement from my experience representing farmers. Those add cost. New farmers often won't do that at the outset. Do you happen to remember? I will say, these are things that the farm would be happy to do. I don't want the commission to have hesitation in making the list and saying, please do this.
Don't.
Great.
So I guess my sort of weighing in on yes, we do need additional information. I think the commission relied perhaps over heavily on the monitoring reports that we had done. So I want to make it clear that we did consider the question of whether there was damage from the parking. We were concerned about it. We didn't just kind of say, oh no, that's fine. But we hire someone to review this property every year, and it was her opinion, based on just a visual observation, that there was, if any, impact, limited impact, which could be remediated. So I agree, we need to go a lot further than that, but I just want to make it clear that we did consider this.
We also determined that they only walk the boundary.
Yeah, and they didn't, and it was anything they
The
did.
parking area is not in the boundary.
Okay, for that, at least for that one. Yeah. So we have done some due diligence, but more due diligence is necessary. I would say I personally, again, this question really focuses on soil health. If we are going to allow parking on the easement, I feel pretty strongly that we need to also be able to evaluate how it impacts the other purposes of the easement. So there have been a lot of questions about water quality. There have been questions about visual sort of aesthetics, and those will need to be considered and addressed. And I do have a question for you. When the site plan was originally, when the site plan came to the planning board, parking, and I wasn't there, so I don't know the answer to this. Was parking requested to be on the easement? I guess why? Why parking on the easement in the first place?
Okay, so just to clarify the factual situation, parking had been happening on the easement, was depicted to continue happening on the easement, and was approved to continue happening on the easement. And it's because there is not enough room between where that little historic structure is, where the farm stand operates, where the farm stand parking operates, where the structure that is used for their walk-in freezer and walk-in refrigeration is located, where the agritourism events are located. And I think everybody agrees there needs to be a safety distance between where the agritourism event, public centers outside of vehicular traffic and where vehicular traffic flows. And when you put all of that together, there's not room for vehicular traffic outside of the conservation easement area. And I just want to say, I noted in correspondence the anticipation that one conservation easement member is going to start joining the annual monitoring. And I think that will help with institutional on the ground understanding of this. And I think Nicole may want to add something. Yeah, and thank you. So the site visit associated with the planning board site plan review included walking right through that area, pointing out that this is where parking occurs. So that was, you know, well on display.
So, yeah, so I at least would want to understand, and I would even need to walk that site myself.
Yep.
Not so much, clearly there is some parking available in the exclusion area. So when people come to the farm store and they buy stuff, they park in the exclusion area.
Yeah, and there's a site plan for that because there was a 2015 was the first site plan, and that was for the farm store. And that includes a parking lot layout for that. And I'm going by memory, but I want to say something in the magnitude of like 10 to 12 parking spots.
So there are some events, and where I'm going is what I would like to see eventually. I mean, I would like to talk about minimizing parking on the easement. So when you have smaller events, when we sort of come through whatever plan you're going to come through, I would like to see a plan for minimizing parking, which may include using more of that smaller area for smaller events. So just something to think about. And that was just part of that John Hayden exchange was me trying to understand that chain of events because I just didn't know what had happened there. Thoughts?
I think those chain of events are important, but I think we fully explored that. But it's moved.
Nobles could be here a long time, so, yeah.
I think it's important.
Please. You got Chris.
Okay.
Yeah, nothing. Allison talked about that it is important to understand the history and the chain of events, but we have time to delve into it.
So what other concerns do conservation members have regarding parking that they would like to see either more information on or in this motion that we're about to make, some kind of either limitation or qualification?
I think one thing to consider is where the parking is happening. So it's sort of in an area where there's a lot of normal traffic, I would call it. There's tractor traffic, there's chicken trucks picking up chickens, there's stuff being stored. I think Sarah Callahan mentioned that in one of her memos, that it's a working commercial farm and that should be expected. But I think if we drove by and there was, you know, a Chevy Tahoe in the middle of the field, that would be different, right? So somehow limiting the area to that commercial or the well-tracked area. I don't know what you.
Where the farm equipment.
Yeah, it's like the flat part before it slopes down.
That was a point I was gonna bring up too, because I noticed that once this is overflowed with parking, they park down here and eat, which is way outside the parking area. So you mentioned Chevy Tahoe down here, but there'll be lines of vehicles down there.
We now,
I agree with that. I think that there can't be overflow parking that goes more on the easement. You know,
Right.
like if it's whatever is designated is it.
are we talking, I misunderstood. I thought we were talking about soil testing here, but now we're talking about what sounds to be like a planning board issue. I don't think this is within our purview to explain. We made there was a vote that passed on parking. Now we're talking about that it's okay on the easement, but now we're talking about remediating soil. So, but it sounds like we're talking about where within the easement we can and cannot park, which to me, and I'd have to go back and look at planning board notes, but this gets outside of our purview as a conservation commission, in my opinion.
Allison did ask what other concerns there were, and one of the concerns I think that I have.
On soil testing though, so we should be sticking to what.
The zone has to be defined.
I know, so, yes, you may, but I will say this, but
Let him finish and then you could go.
Allison asked what concerns, other concerns we might have that could impact the quality and the protection of the easement, right? The concerns that I have are the number of events that were allowed by the planning commission and the number of vehicles and people that were expected. Currently, they're operating at far less than that allowed capacity. I saw the property, I walked the property where they have been parking this year. The grass looked great. So even though it's been a dry year and could have been a very tough year, it looked very good. So it didn't seem like it was exceeding the capacity of the land. But is that always going to be true, both in terms of the numbers of events and the numbers of people? And that's where I think as a conservation commission, we can make recommendations about the planning commission and the plan that they had previously approved.
So I do not want to get into advising the planning board, but we can create our own sets of guardrails. So we don't have to go back to the planning board. We can say, and the place where it's not soil. So in the AG's question, it says, does parking in the easement area significantly impair or interfere with the conservation value of the easement? And parking and the soil. But I think that it's within this question to also address some of these other issues.
So we have the authority to determine where within the easement, so
No.
we can restrict.
No, well, I don't know if we do or not. I don't know.
I
if
mean,
we
that's
want
where
to.
it gets dicey with that.
I personally don't want to get into, saying this is exactly what you have to do or not do. The way I would prefer to go is to say, as we have sort of put into this potential motion, that we require a plan. So the onus is on them to come up with a plan that ensures that the integrity of the easement remains. And it's not up to us to tell them where they need to park, but they need to prove to us with a third-party professional association that parking has been minimized to the extent possible. Does that make sense?
Yes.
So I don't want to get into the details of exactly who does what. I want to be clear about what we consider important issues that need to be addressed in whatever plan they come up with. Without too much in the details.
I think it might be important if you just read that paragraph again, so that everyone's clear on what you're voting.
So this is the question. So this is not what we're voting on. This is the question that came to us from the Attorney General's office. So this is not the motion. So the question from the Attorney General's office is, does parking in the easement area significantly impair or interfere with the conservation values of the easement? Part A, has the town taken effective steps to determine that the parking does not negatively impact the soil? And B, if parking does negatively impact the soil, can it be remedied afterwards, i.e., are the negative impacts merely temporary, and by what process? So we're not voting on that. That's the question we're being asked.
So you need to formally answer that.
We will come up with a motion to address that question. Right now, I'm just asking what other significant concerns the commission has that they might like to have included into that motion.
In that parking, you still have the fuel cube, restrooms and dumpsters and waste oil in there too.
So I think that's important, but I do think that's not parking.
Servicing vehicles are parking.
So I think we're talking about members of the public. So I do think that's important, and I did bring that up with our easement monitor. So
Yeah.
that is going to be looked at.
It's the important breakout here.
So sorry,
The train isn't helping.
the question of parking, service vehicles, other items that are on the easement that maybe shouldn't be there. We did bring that up with our easement monitor, and we did ask her to specifically look at that. She has not been out there yet. I don't think that that's related to the exact question that we're asking, except that it comes under this make a plan that
And it
protects the values of the,
significantly impair the soil.
so it's relevant in the sense that it is something that would be considered under this plan.
Allison, is there, you mentioned, I think, it's a couple farm, you mentioned a couple that have parking. Is there a regimen, existing, is there any way that we can learn from what they're doing? If there's parking occurring?
Very strict record of all soil mitigation, actually, extremely.
I did
It's
ask,
planned out from month to month and all kept.
yeah, I asked the Conservation Commission, and they are not requiring any particular action, but she said, sort of like you said, she said he rotates the fields, and they seem to be, yeah, they weren't looking into it from the commission side in detail, but
He keeps full record, so if you went and asked him, he can show it to you.
you want me to try and make a motion? You want to keep discussing this?
We want to try and make a motion?
When you, there's draft text to two bullet items.
Take a draft text, cover it with red ink if you want to. Go for it if you want to. And again, we have draft text for several eventualities that cover different possibilities here.
I will state the motion that the town and the Vernon family farm have additional steps to determine that parking in the easement area does not significantly impair or interfere with the conservation value of the easement. Accordingly, Vernon Family Farm shall work directly with the NRCS or equivalent entity to assess soil impacts associated with parking, if any, and develop a plan to mitigate any negative impact to the soils, including but not limited to soil compaction and erosion. As part of its assessment, NRCS or equivalent shall assess whether limitations should be placed upon parking to ensure the long-term integrity of the soils and other conservation values for the purposes set forth in the original easement deed. Vernon Family Farm shall provide a follow-up report to the Conservation Commission by a date, May 1st, 2026, not a date doesn't in the motion.
Right. I need a second. Again, you get on,
I just wanted to repeat, please. It's a lot.
okay.
I'm sorry.
Yeah.
Yes, here to repeat.
Thank you.
The whole, yeah, okay. The town of Vernon Family Farm have additional steps to determine that parking in the easement area does not significantly impair or interfere with the conservation value of the easement. Accordingly, Vernon Family Farm shall work directly with the NRCS or equivalent entity to assess soil impacts associated with parking, if any, and develop a plan to mitigate any negative impacts to the soils, including but not limited to soil compaction and erosion. Period. As part of its assessment, NRCS or equivalent shall assess whether limitations should be placed upon parking to ensure the long-term integrity of the soils and other conservation values for the purposes set forth in the original easement deed. Vernon Family Farm shall provide a follow-up report to the Conservation Commission by May 1st, 2026.
I'm sorry, second, I need a second.
This is motion.
By default, not the plan.
Hold on, we need a second before we get too far in discussion. So we have a motion on the table. I need a second for that motion. Okay, discussion.
I would suggest that in addition to a report, we ask for a plan from the Vernon Family Farm.
And I'd say, having thought about it some more, I would also like to say that that plan needs to be approved by the Conservation Commission. What we have now is a plan is required. They give it to us, but we don't have any, we don't do anything but accept it. So I would like a plan that needs to be approved by the Concom.
Approved. Okay.
May I, plan has two different meanings. Plan can mean a visual document. Plan can also mean a narrative document made of words. Would the motion please specify what version, that definition, please?
Writing.
Yeah, so I assume you meant a written plan. This is what we're gonna do. This is when we're gonna do it.
Not a plot plan.
Not a picture. plan.
Thank you.
Yeah, I meant a written plan about what is going to be measured, what the results of the initial measurements are, what that indicates that should be done. So yes, I definitely meant a written plan.
Should I repeat the whole thing or just the last sentence?
Probably the whole thing.
Just do it one more time for clarity.
Okay. The town and Vern Family Farm have additional steps to determine that parking the easement area does not significantly impair or interfere with the conservation value of the easement. Accordingly, Vernon Family Farm shall work directly with the NRCS or equivalent entity to assess soil impacts associated with parking, if any, and develop a plan to mitigate any negative impacts, a written plan, excuse me, to mitigate any negative impacts to the soils, including but not limited to soil compaction and erosion. As part of its assessment, NRCS or equivalent shall assess whether limitations should be placed upon the parking to ensure the long-term integrity of the soils and other conservation values for the purposes set forth in the original easement deed. Vernon Family Farm shall provide a follow-up report and written plan to be approved by the Conservation Commission by May 1st, 2026.
And I just want to say, and I don't know if we want to put this in here or just say it. This is very soil heavy, but I think these other values, including the view and water quality, which have seemed to have come up over and over again, if they're not addressed in this plan, they're just going to keep coming up. So those need to be addressed in this plan, and we can either call that out in more detail, or we can leave that wide open.
Just call it out in more detail.
Okay. I'd say other conservation values, including, I need to go back to the purpose of the deed. I want to make sure we're reciting actual purposes, not ones I make up.
How are you gonna go backwards on the view now?
I think
Nobody does, yeah.
it has been, but it doesn't have to get worse. Including, so
Madam Chair, before you get too deep in the wordsmithing, NRCS and similar are not going to engage in aesthetics. Water, yes, but I would request that we have a separate sentence about the aesthetics, because that is not, within their bailiwick. Thank you.
In that case, the sentence would read, assess whether limitations should be placed upon the parking to ensure the long-term integrity of the soils and other conservation values, including water quality. Actually, I'm changing that, sorry.
There's those three words.
long-term integrity of the soils and water resources. And it's in the long-term integrity of the soils and water resources. And then in addition, so I'm trying to separate this sentence from the NRCS place. In addition, the plan will address, let's just say we'll address other conservation values, including,
As mentioned in the easement.
yeah. Or just say, how about if we just say the other purposes of the, sorry, it's hard to get these right. I don't want to put in too much detail, but I just want to make sure that we're not just constraining ourselves to a bunch of soil tests.
The, language in the easement is the scenic enjoyment of the general public is viewed from Piscassic Road.
Amy, please repeat that.
Sure. The scenic enjoyment of the general public as viewed from Piscassic Road.
Within the easement area. Had some comments that there's fencing now that used to be there, so the view's not there. It's like, well, that's
Not as being required by the ZBA.
Yeah.
So when we're talking about plan submitted to us, just mitigation plans or plans of the events?
Not the events. So this is just a plan for managing the impact of parking. Is that not clear in this?
And what the date is, the date we receive the plan or the date we approve the plan? Because
Thank you.
there has to be a time given for us to review any plan.
Right. So I would say approved by May, because you want to have your events, you can set that date if you want to set it earlier, because you need to be able to set up your events.
My concern is more the soil being ready for a soil profile. And if there's snow on the ground in the beginning of May, which there has been in the past, I don't know if that's possible.
Okay. But the plan doesn't have to wait on soil tests necessarily.
Okay, so
I think that the date is fine, so long as it's understood that, the full range of data from in-ground and on-the-ground analyses may not be until the 2027.
The plan would include the process of,
What's going to be happening between the 2026 and the 2027. And as you're writing this for your approval. So if it didn't meet with your approval, you would be telling us that. Yeah, but thank you. We do need the clarification on the date of submission versus whether that's going to be the date that you're acting on it.
I believe your planning committees, their initial submission goes in
The last day of March.
in line up that they submit both plans at the end of March.
What that would create is twice the amount of work on doing the same day. Yeah. I mean, this date is fine with us as it is, with that acknowledgement that we just discussed, if that.
May 1st is the submission date, and since we normally meet as a commission on the third Wednesday, we wouldn't be giving you an answer until the end of May. So
Yeah, I mean, and I just want to check here, the answer is not going to be, no, you can't have your chicken crop this year. you know, so they're not going to be hindered from starting the, the production of their agricultural products. Right? Am I misinterpreting what is envisioned?
It's only related to parking.
Right. So I think we're okay.
Yeah, it may be that based on the NRCS, those results, you can't park as many cars, you can't park them where you expected to park them, so there may be a reduction in parking. And the language does specifically say, Lori, so it does say, shall assess whether limitations should be placed upon parking. So that's potentially limiting the number of cars or limiting where they go. But it's based on use. It's not based on number of events.
So just to make sure we're all on the same page here, because we want to continue a good collaboration. So the first, what we're going to plan to provide on May 1st, 2026, I wrote 2025 in my notes, is a,
No, sorry.
yeah, it's getting late. An expert informed plan for assessing whether the language that you have here, soil compaction, if any, is interfering or significantly impairing with the soils, or I didn't quite catch the water resources part of the language, but that's the plan that we're proposing for next May.
I'm taking out,
Because we're not going to be able to be doing, in December of 2025, in January and February of 2026, we're not going to be able to have experts out there in the field saying, oh, let's look at the grass. Let's look at the grass here. Let's look at the grass there.
yeah,
Let's check how resistant the soil here is here versus the soil is there. Do you know what I'm saying?
you understand what you're saying.
Okay.
Winter and all. You know more about soils. I do.
That's a soils expert.
When's- If we're
We're not
asking,
looking at surface grass though. We're looking at what's underneath.
right, and I understand that it snows and there's mud, but there's assumably some time of year in which that work can be done. Do you have any sense of what that window would be?
Would have been a month ago.
Yeah, so there's going to be some lead time. There's just going to be a tiny bit of a lag here in terms of, May 2025. What will have been accomplished is identification of experts. They do not work for free. There's going to be development of scope of work and contracting and all of that. Proposal of a plan, what exactly we think we're going to do, where are we going to do it, when are we going to do it? That's what we'll give to you. I'm sure I'm missing some stuff. Then performance, summer 2025 results. There's no reason we're going to 2026. There's no reason we need to sort of wait all the way until May 2027. And then it's going to be an iterative process. Like, okay, this is what we found. Based on what we found, this is the other stuff that we're going to do. Or guess what? Yeah. But now we have the data, so everyone knows. I think given the timing, that is very reasonable. And that allows you to answer the questions that have been put to you in a way that very amply satisfies your legal obligations.
Question for Chris. You do have you can't. Ideally, soil samples, when you're taking them,
Soil,
winters,
you'd have to be in the
Yeah.
summer
gotta be.
point, yeah. Because they'd have to, the water samples, probably same time frame. And if we're only gonna require one a year, then ideally it would be the same time every year type of thing, but that would all be part of the plan.
Right, yeah, and my understanding is you're not only requiring one, you're requiring us to confer with the experts, and we're gonna tell you what they're saying.
Unless other people have, that would be my expectation.
Yeah, I guess my only concern about that is then we enter the 2026 season and we haven't done that assessment. You're going to make a plan with events, with parking, and we don't know what the impact of that parking is. It's already kind of launched.
Yeah.
That's my concern. I'm not sure.
And I don't think that, I hear your concern. Our perspective on that is that the Conservation Commission is dramatically upping its game on its sort of hands-on, on-site due diligence here from a third party once a year monitoring, and then we talk about it at the meeting, and then we're done, which is totally legally sufficient. I am not saying you guys have been not meeting your obligations, but now you're going to have one of you go on site. You're going to have this in addition to the management plan that the farm already submits and follows. We're going to have this second plan that's an annual plan. I mean, I have never heard of a conservation commission in New Hampshire performing this level of due diligence. So I hear your concern. I think it's a inconsequential gap that is unavoidable based on the timing of where we're at. And keep in mind, as I'm sure you all know, the parties are in litigation in Superior Court. The Vernon Family Farm, and that is not going to end between, now and when Vernon Family Farm submits their next annual calendar. So this is not a binding statement, of course, but I do not foresee that Vernon Family Farm is going to plan a season next year that maxes out what they're allowed to do under the planning board approval. I do not see that in the offing. That was not the current plan, right?
No, and
Yeah.
it wasn't in previous years either.
Right.
We were always doing about 50% of what we're allowed to do.
Yeah.
I think the commission, I mean, there is a lot of talk about a huge burden of testing, which can just go on. And with the multi-site testing needed can turn into a lot of work for little information. But as Lori expressed, the commission is concerned about putting guardrails on things. And one that I did bring up, might not have gotten out, but for example, the parking has to be in a clear area and never to be exceeded, because then the testing all gets wonky because you now have to go into a different area. So no overflow, for example, moving down into the road down there, something like that on the easement. So there does need to be there's concern here about putting some initial guardrails up, I think, for the 2026 season that might be in and above what the current allotment allows for. But then there will be continued monitoring, which will be a game up version. But I don't think that just putting tons of testing onto this is where we're really heading towards, or where we'd like to go and achieve.
I think that's up to them
Yeah.
to put into their plan. They can work out what will meet the needs at a reasonable, I mean, yeah, I think that's up to them.
In the plan.
Yeah.
Whatever and we would approve it, so.
Yep.
That would be, but,
If we consider it insufficient, we could always not approve it
right,
Right.
with good intent.
yeah.
If I may, Vernon Family Farm is exceedingly proud of its stewardship of this piece of land and its relationship with this commission. The farm hopes that the commission can trust in the farm's continued stewardship of this land. Keep in mind, this soil is where they get their livelihood from. So no one is more incentivized than the Vernons to maintain the integrity of that natural resource.
Thank you. So do you want to read what we have?
How do we want to get this scenic view part back in here that without turning it into a whole new? I think it's covered by just the terms of the easement deed for the purposes set forth in the easement deed.
Okay, if we
Or I could say,
leaving it open like that is okay. I mean, it's covered. It's just whether it's helpful for us to pull it
Maybe.
out. What do you
plan shall also address
think? Plan shall also.
scenic.
Yeah, that doesn't mean we're telling you what you have to do. Just telling you that needs to be part of the plan, that you've considered that.
We will, this is new for all of us, so we will do our best. And you'll tell us how we did when you review it.
If you read that through, that it's, the plan is submitted by May 1st.
Yeah,
They have requested as opposed to submitted and approved by May 1st. Submitted by May 1st.
Submitted, say submitted.
oh, right, to be approved, right, yeah.
or-
Yeah.
Because that makes it.
Submitted May
Yep.
1st, by May 1st for Conservation Commission approval.
Right. Okay, so I'm gonna start from the top, Ken. The town and Vernon Family Farm have additional steps to determine that parking in the easement area does not significantly impair or interfere with the conservation value of the easement. Accordingly, Vernon Family Farm shall work directly with the NRCS or equivalent entity to assess soil impacts associated with parking, if any, and develop a plan to mitigate any negative impact to the soils, including but not limited to soil compaction and erosion. As part of its assessment, NRCS or equivalent shall assess whether limitations should be placed upon the parking to ensure the long-term integrity of the soils and other conservation values, including water resources, for the purposes set forth in the easement deed. And the plan shall address the scenic view from Piscassic Road as well. Vernon Family Farm shall provide a follow-up report to the Conservation Commission by May 1st, 2026 for approval at the Newfields Conservation Commission.
Follow-up plan. On report. They can't get the report yet, but they can do a plan by.
I believe I said follow-up report and plan. No report. No plan,
No report.
follow-up plan, yes. Just the plan. Follow-up. So the last sentence, Vernon Family Farm shall provide a follow-up plan to the Conservation Commission by May 1st, 2026 for approval by the Newfields Conservation Commission.
I don't think, well,
I don't think you need follow-up.
Yeah.
No follow-up.
No follow.
a plan.
May we put written
No. Vernon,
written plan?
problem, yeah, things written down. Vernon Family Farm shall provide a plan,
Written plan.
Plan.
Sorry.
Written.
written. Sorry. Last sentence. Vernon Family Farm shall provide a written plan to the Conservation Commission by May 1st, 2026 for approval by the Newfields Conservation Commission.
Derek, thoughts? You paying attention?
No, yeah, I mean, I think that's fine with the first couple words, but it reads perfectly fine. Yeah.
Okay, there's a process here and I forgot it. We've now amended the motion. Someone help me out. We need to vote on the amended motion or do we need to vote to amend the motion? Derek,
As amended.
or do we need to?
as amended, the second, right?
Oh.
The second motion. Yeah. You can just vote on the amended.
Vote on the amended, okay. Any more comment, conversation on this? Okay. All in favor of this amended motion? Say aye. Aye. All opposed? Abstain? Abstain. Okay. Thank you very much.
I do want to clarify that we are, the farm is good to go maintaining the status quo as we move forward.
Yes.
Thank you.
So on this, on the second amendment. So just, be clear that the first motion very clearly tied parking to agriculture. So, and there are some specific instances of agriculture in here. So you really need to be tying this to the food, to the scenic enjoyment. I don't think if there are events that are happening or people could just go to an event without specifically engaging in those agricultural activities, that's going to be a problem.
Understood. Yep, that doesn't occur. So we feel very confident.
Okay, anything else on these? No. Okay. It is 9:00. We are going to conclude this part of this discussion. Do you want to take a break or do you just want to dive into budgets? Break.
No.
No, we're diving, we're
Yeah,
diving
they're
in.
done.
Diving in, okay, diving into budgets. You all can. Derek should be too. He doesn't want to. Sorry to.
That's probably not.
Same place.
No.
Got a flask in my bag. Something I had a opportunity, last summer to have anything in their wine cellar. They make a lot of it out. We might get a favorite one. And I moved there, and we pulled it up, an arcade shop right on the street. One of the mortgage all day. Is that it? Have you seen the new building? Yeah. Oh, amazing. So all the silos, like, if you can lift off silos, literally they're spending half a day with them moving silos. The owner comes out and goes, hey, go take a look at the, line, there, pick anything you want. I'm like, I turned it down. And I'm like, I'm just helping out a neighbor. One of the guys came up to me, like, dude, he's got some like 100-year-old bottles of whiskey in there. Big on it. I'm like,
What I did with my.
yeah, I used to know the old owner who was there, Frank. Reinhold. Retired submarine captain. So he inherited that with a contingency in the family to be used for agricultural purposes. With the winery.
On here, folks. You're talking agricultural.
So whether you are
Long.
gonna be discussing.
Okay, I have lost my copy of the agenda on the various messing around here, but I thank you. So we're on to
No.
treasurer's report. Don't know what that is. Okay. Okay, so for the month ending October 31st.
Please.
Excuse me,
Still go.
For the month ending October 31st, our conservation account has $74,260.47. having earned a dividend of $263.22. Our current use account has a balance of $21,369.76, having earned a dividend of $75.75. Up until this point, there had been limited spending. We have submitted the invoices for the recent easements that we were approved on November 3rd. So those will be coming through. The list of costs I have included in the proposed budget. So I would, if there's no questions about the current accounts and the conservation account, then I suggest that I move that we accept that report.
Second. All in favor? Okay, so just, we have Mike here, so convenient. There were questions about how this funding got into this account. This actually predates my time, but my understanding is that this is primarily current use funding. It came to the Conservation Commission. And then when the town voted for the two big land use bonds, the Greenway and the open space, decided to discontinue sending the current use money to the Conservation Commission because the town was paying the interest on those loans.
That's correct. In effect, the town saw that paying on those bonds was basically the town's large contribution. And so it basically was utilizing open space fees in the operating budget until those bonds are paid off. Once those bonds are paid off, all of the open space fees will now revert back to that account.
Are those bonds paid off?
2026. Yeah, 2026, the bonds will be paid.
Okay. Yeah, so
If you go open space money, will go into that account.
saying we've been holding on to this money for 20 years, so we might consider whether or not there are uses.
And it doesn't require another vote for the town to do that. That was the terms and conditions that it would then start reverting back.
That's my understanding. That's nice. Okay, great. I hadn't realized that. So good to know. So we do have this funding. We may have some trickle coming in the future. And that, as we did, budget is next. Wait, do we have to present to you guys? Yeah. I was getting budget is next. But just for your information, the budget that we present to the select board will come from this year's annual appropriations. If we want to fund something out of our existing account, that does not have to go through this budget process. So it's not like we have to decide if we want to do something with that money this year. We don't have to decide on that right now, just for clarity.
The money that's in our accounts currently.
Correct.
Okay. The budget as proposed didn't even consider that.
Okay. All right. So do you have the proposed budget for next year?
Yes, and so the 2025 budget as approved had easement monitoring at 3,500 for 7 easements. Expenses to date were 399, but we've got 3 more that are in there and 4 that are coming. We had Great Bay monitoring at 1,000. We have paid the 1,000. We had SRLAC at 200. We paid 300. It will be 300 next year, according to their invoice. So that would be the proposed budget. NHACC, also a voluntary amount. We had 200 approved. Nothing has been paid yet in 2025. So I put in 250 by looking up the proposed membership fee for next year. The recording secretary was budgeted for $600 for this year. As of 30th of September, we had exceeded that. No, sorry, it's the 30th. I didn't change that date. It's the 31st of October. We were up to $768.75, largely because of last October and November's meetings.
Because we keep having long meetings and needing more for time.
So I just put a COLA type increase in for 2026 of 620, but we can talk about that. Email fees, we have a budget 2025 of 714. Nothing has been paid yet. So we don't know what the actual fees are for 2025, so I didn't put a number in there because I have no information. Just Lori did get some updates for the easement monitoring, I forgot to mention. So the 2026 budget as proposed for the easement monitoring would be 4062 based on the estimates from Ariana. So the total for 2025 budget that was approved was $6,214. And the total without the email fees right now is $6,232 proposed. So we need to increase that for probably another 700. So let's say $7,000.
And that's the extras for the email fees?
The email fees. Yep.
Question clarification of the email fees, is that for correspondence with the consultants or our accounts?
That's our.
Okay.
Yeah.
Is there anything added in there? I know we talked about server space or something for,
SharePoint or something.
yeah.
I don't think so. Do I
It's
get?
just like a $5 a month it's a ridiculous amount of money to be spending per email, but that's what you're
Yeah.
paying for.
Yeah, the question was, and I don't know if anyone here knows the answer, but if not, the question was whether it's something like, often when you're working with Outlook, you have SharePoint, so you have space on a screen to store stuff. I don't know if that comes with these emails or not.
I probably
I think you could take the main Concom email, use the OneDrive account, and make a folder that's shared with members and control it that way.
So you think there is a OneDrive?
I would assume so. Yeah.
Okay, yeah, so we can look into that. The other alternative is to get space on the actual town website. The advantage of that is 10 years from now, when we've all forgotten our passwords and moved on, somebody
Yes,
still
right.
has access to it. So I think honestly, that's the best way to go.
a central point for the information to be pulled.
Yeah,
Yeah.
and it should be on,
Yeah.
something that a town employee has access to because we rotate through. So,
And I didn't put anything in the budget for it. We've been talking generally about what other things could or should we do as a commission, but since we had not discussed that, I figured it was inappropriate to add it for 2026, and that would be part of our discussion in December and then into the year in terms of what else we would like to do as a conservation commission for the town of Newfields.
and I think,
I can send an email to Sue, but I think if you ask.
I'll ask her. Yeah,
We have a central point of data storage.
Yeah.
How do we set that up?
I'll do that. Yeah, and generally what we have put in the budget are sort of general operating expenses. So one-off projects that we might want to do, we either face the funding for, or we use our accounts for. So this is mostly sort of administrative. Anybody else? Any thoughts on that budget? Additional things we've forgotten? We're all confused here, but there we go.
Those of you that have been around longer, this is what I got for,
This is pretty much what we do. We just recycle last year's. Every once in a while, something goes on and off, but not, and then tomorrow I'll come to the select board meeting and we'll get feedback.
you need to do anything about voting on this? I mean.
Yeah, we should vote to just run us over those numbers again, and then we will vote to accept that as our proposed budget.
Quickly in my head, but it's $4,062 for easement monitoring. There was a question about $1,000 for Great Bay monitoring, because we had discussed it a previous.
Leave that in for now.
Leave it in for now, okay. $300 for ESR LAC, $250 for NHACC. I guess, do we want just 620 for the recording secretary, and understand we may go over if.
Yeah,
Okay. And then, I didn't do a cost of living increase for the 714, but I could come up with, let's see.
and I don't know, Hobie, maybe I can ask you now. So like the recording secretary doesn't we don't see those bills. They get paid out of the town accounts, right?
It's coming up in our totals.
Yeah, it's in our budget that we propose. So would you rather, given that we don't know exactly what that number is, would you rather that we present a budget that we think is a little high and maybe not use it, or? Yeah,
If it needs to go, and if you need to bump it up. That way it's clear and transparent and it shows what money's going, so.
yeah,
You have best faith that.
okay, so just sort of base it off what this year is and, okay.
Okay, so 6. Okay, so the proposed total budget would be $6,967. Sorry, 6,967. Yeah, that's what I said. Sometimes I mess it up.
All right, I vote that we accept that proposed budget. And I'll present it to the select board tomorrow. Any discussion? Their discussion? All right, all in favor? Aye. All opposed? Okay. Great. One last thing we did want to talk about. So last meeting, we talked about the CSX parcel and working with the select board to try and at least get some information about what we might need. And then if there's any way to move that forward, working with the select board on trying to acquire some access or understand at least what that situation is. I think that we have been asked to formally make a motion indicating that this commission is supportive of that idea. Is that what this, and is committed to helping the select board move that work forward.
Did you submit that letter that you sent?
I sent it to all of you to view and edit, and you all gave me your feedback separately. So we can put something together that's a little more finalized, but the idea is what we sent to you. It was maybe a sentence or two in the email that was inconsequential, basically.
Ideally, I think we would have a smooth copy presented to the board that everybody have reviewed and signed off on, instead of still working on it. So that we can move that and take that and use the select board letterhead and right to CSX. So.
I think that we have seen the revised version because that was done by email. So we've seen the revised version.
So just forward it to us. And if tonight, you're just going to vote that you're going to submit, that you're approving that we would submit it.
Right. We are not submitting it. We tell me if I'm wrong, but I would make a motion that we, as a commission, support the select board submission of the letter that has been written and approved, and we'll work with the select board to move that work forward. Michael has a comment.
Mayor,
Yes.
Suggestion is that the chairman of the select board and the chairman of the conservation commission should actually be the signatories of that letter. Because I think the conservation commission indicating their interest in this will actually have some influence on CSX as opposed to just the town. Because the CSX will recognize that this isn't being used for the town to just acquire property, but actually for conservation, which, you know, they're gonna lean towards supporting if they think that they might dispose of the property. So my suggestion is that the chairman of the select board, chairman of the conservation commission should be the two signatories on that letter. Just as a guide.
I have no idea what CSX wants. If we think that would be beneficial, I'm fine with it. What do you think?
I think it shows united effort and move forward together.
Okay.
Actually, we like when, so you're gonna have a smooth ready for tomorrow night. It's approved.
Yeah, we've got one in your email.
And then we'll have, and the entire board will see that.
Yes.
It's fine about.
Okay, should I go back to making a motion or are we clear?
I second it.
Okay,
I mean, for the purposes of saving time, I mean, you could read it off if you want, tonight, or,
sure. Just read it right now. And then we have,
I sent this off to you and I will.
and the only difference, yeah, just the signatories will be the two of us.
Okay. You want me to read it? The inquiry regarding CSX owned property, Newfields, tax map 204, lots 21 and 22. Dear CSX Real Estate Department, the Town of Newfields Select Board, and Conservation Commission is writing to formally express its interest in the property owned by CSX located within our town, specifically parcels designated as tax map 204, lots 21 and 22. See attached map. These parcels are adjacent to the railway and we believe they are key to enhancing public access and conservation efforts in our region. To that end, we respectfully request your consideration of a right of entry or land use agreement. We're committed to working collaboratively with CSX to ensure safety, compliance, and mutual benefit. The town is prepared to meet all necessary insurance and liability requirements to ensure CSX is fully protected. We would appreciate being connected with the appropriate department or individual to discuss this matter. We'd be happy to arrange a site visit or a preliminary discussion to review our proposal for any formal review. We're also open to discussing other possibilities, such as acquisition at your convenience. Thank you for your time and consideration. We look forward to your response. Sincerely, Town of Newfields Select Board, Conservation Commission.
Thank you. Any comments?
I
On
mean,
board
that
with
was
that?
wheeled down a few times.
Yeah.
Based on your feedback, like public access. They don't want to necessarily alarm them to say, what do you mean public access? That they're going to be kids riding bikes near the train tracks, so, you know, that kind of thing. So it has to be clear what the intention is. I think staying with the conservation end would be better. So I can take out public access. Or we could leave it alone.
I would leave it alone.
An open-
I can't imagine the town's gonna want conservation.
Yeah.
I'm
So it's gonna come out in your discussions with CSX anyways.
Yes,
This is just to get them to the table.
yes, right.
Yep, I like it as is. Okay, we have a motion on the table. Do we want to vote on that? All in favor?
Aye.
Opposed, abstain. We're good. Okay, thank you. So I will bring a copy on letterhead. Anything else? I don't think there was any mail. Did you check for mail downstairs?
There's no new mail this week.
Okay,
I have a couple pieces from before. So glad you reminded me.
okay. Anything interesting?
Do any of them need discussion before?
No.
Any of them need payment?
Thanks. Not that I'm worried.
So mercenary.
Trying to
Got spent on my share.
Sorry, we've actually forgotten something major. We need to approve the minutes.
Yeah.
The minutes that were just sent us and the minutes from the October 20th meeting. So as you probably saw, Sue sent out the Cliff Notes version. I think with that Cliff Notes version, I would just like to have both of them posted. I'm okay with both sets of minutes. Did you have any comments on them? You had some minor
Both
comments,
sets of the October 20th.
October
minutes?
20th and November.
I did not get a chance to read the November 3rd. I know those just came in. I just noticed them the other day, so I didn't get a chance to look at those. But the October 20th look.
Okay.
Good. Yeah.
Do you want time to read I read the November 3rd. They look reasonable to me. Did anyone else have a chance to read them? I know it was super last minute and there's a lot going on. So if you don't.
Can we respond by email after we take a look, or would you prefer to wait to the next meeting?
We could approve them at the next meeting.
Okay.
I don't think that's a huge deal.
I feel like that added meeting, and I'm sure you can.
Yeah.
You probably had writer's cramp or typer's cramp from the
Okay.
20th.
Okay, we can put off, so we'll approve. I'll do a motion in a minute. We're gonna approve the notes from the 20th. But we're gonna hold off on the ones on the 3rd till the next meeting. It'll be 2 for next meeting, so there'll be a lot of reading. Okay, I make a motion that we approve the minutes from the October 20th meeting as presented. All right, second, all in favor?
Aye.
Aye. Opposed? All right, anything else?
I just wish to say that I transcribed the bylaws into Word. And I did talk to Chris, and I were kind of interacting, a week ago, or I guess it was 2 weeks ago now, about teaming up a little bit on that. So they have been transcribed to Word, and I think I'll submit them around, and they'll just be on the, we'll make a editable, change tracking document out of it, and then we can put in what we want to get done by next month. It does say that we have to get it completed in December. And so we can do let's just say a good, accurate change for this December meeting, but we could also make a change, I believe, to allow us to change it before next December. And I think that would be good if we want to really get in and to give it a fair amount of time to get things perfected for how we really want the bylaws to look. Because I think we're a little jammed for time. So we'll submit that around, and that'll be, I guess, the topic of discussion and email for the next weeks, if you don't mind.
Good, and we'll discuss.
Should have basically the same document. It all seems to have been adapted from the state.
Everybody just pulled it
Yeah,
off,
yeah.
but that doesn't mean we can't make it better now.
And it doesn't address virtual meetings at all, whatsoever.
Yeah.
It doesn't address alternates. So we need to do a few things in there, but maybe there's just a couple, we can get them all done. You have latitude, I think, to make another change next year, so we're not locked in for 12 more months. Okay, that's it.
Okay. Great, in that case, I move that the meeting is adjourned at whatever god awful time it is. Oh, it's only 9:30. Okay.
Second.
All in favor?
Aye.
Nobody ever says no. Okay, go back.